Nau mai, haere mai, inga reo, ina mana, inga karangatanga, tēnā koutou, tēnā koutou, tēnā koutou katoa. So welcome everybody, my name is Nick Smith and I have the privilege of being the Vice-Chancellor at this University of Victoria, University of Wellington, Te Herenga Waka. And it is again my privilege tonight to welcome all of you, family, friends, distinguished guests, academics and professional colleagues, and students to tonight's main event, the inaugural lecture of Catherine Iorns, Professor of Law. This event, like many things that are wonderful, has taken a long time. Although Professor Iorns is promoted to her position in January 2020, the inaugural lecture has been rescheduled 3 times due to lockdowns, the busyness of university life, and no doubt many other vicissitudes. I'm thrilled that we can finally host it here tonight. Catherine's interest in law, as I understand it, was sparked first by her father, a philosophy lecturer here at Te Herenga Waka, who suggested he try it. She's just been telling me about her stories growing up as the daughter of John Iorns, a man who, as I understand it, didn't wear shoes until she was 13 when he finally had to take a sabbatical in Scotland. And who had a really colourful series of upbringings, which I know Catherine will talk about, and I won't steal her thunder, but I think we'll hear about nudist camps and hippies within the frameworks of law that we would otherwise get. Initially, and I've just described Catherine as a Renaissance lawyer, and I think that has borne out through her early interests. She explored a range of subjects: philosophy, in credit to her father, political science, maths and computer programming, but it was ultimately that law that resonated with her. It came naturally and she found herself drawn to the arguments and the reasoning, and she quickly realised that it was not only what she was good at, but it was what she also loved. She then extended that as an alumnus here at Te Herenga Waka to study a Bachelor of Arts and a Bachelor of Laws with honours, and she went on to then do a Master of Laws at Yale University in the United States. In her career, she is an award-winning researcher on environmental law, indigenous rights and statutory interpretation. In keeping with her Renaissance interests, her expertise is wide-ranging. She focuses on projects that have spanned fundamental principles, the rights for nature and human responsibilities, climate adaptation, environmental futures, toxics, I don't know what they are, but they sound worrying, and Antarctica. She's won numerous awards, research awards from this university, publication awards in resource management and law from the Resource Management Law Association, and senior education awards from the International Union of Conservation of Nature Academy of Environmental Law. But in keeping with that Renaissance focus and that Renaissance ability, she's also a leader in external engagement and has extensively contributed to our broader community in a whole number of ways. She works as an advisor for the New Zealand Council of Legal Education and an advisor for the Environmental Law Initiative, and she also actively engages in volunteer work, including serving on boards of human rights and environmental organisations which have spanned her career. She currently has a role with the International Union of Conservation of Nature, one of the largest international environmental organisations in the world. In teaching, she shares how she looks to encourage students, not just by understanding the laws, but also critically evaluating their flaws and considering how they can be improved. She highlights how it's often about asking the right questions, identifying problems and assumptions, and knowing how to make a good argument. And clearly that is all assembled via her teaching methods to earn her an International Teaching Award only a few short years ago. However, in this career, which has been littered with accolades from research to engagement to teaching, she also has perhaps one of the most competitive and the most prestigious awards given out by her host faculty in law, which is first place in the baking award for her Anzac biscuits. Outside academia, Professor Iorns is an avid walker, known for her work and walking on treadmills, and she encourages her students to keep active. She's also the mum of 2 boys who I understand are here in the audience, and 2 white cats who I understand are not. Nobody tell Donald Trump. Tonight, wearing her mother's greenstone and her father's academic robes, in a lecture entitled Unconfirmed and Unseen Precaution and Protection in Environmental Law, Professor Iorns will address the features of the development and application of environmental law in Aotearoa. Illustrate how a disparate collection of academic research and teaching interests can combine with legal practice, community activism, and an added dose of serendipity, resulting in the exceptional decision to protect an outstanding natural feature. This is a lecture that I'm thoroughly looking forward to, and I'm sure you are too. So with no further ado, it is my enormous pleasure to introduce to all of you Professor Catherine Iorns.
E nā mana, e nā reo, e ngā rau rangatira mā, tēnei taku mihi atu ki a koutou, e papatu ānuku, te whaia, tēnā koe. Ko Whanganui ātara, te moana, tihei mauriora. Ko Koukou, te maunga, ngō Ngāti Pākehā me Ngāti Pōneke, o Kuiwi. Ko John Iorns, tōku pāpā, no Wairarapa ia. Ko Rachel Holmes, taku whaia, no Kaikohe ia. Ko Catherine, tōku ingoa, ngā mihi nui ki a koutou, no reira tēnā koutou, tēnā rā tātou katoa. Greetings to all of you. And I started with Papatu Ānuku, or Mother Earth, and I'm acknowledging all of the distinguished guests here. We've got honourable justices of our courts, Chancellor, I believe the Vice-Chancellor, of course, lots of very important people, everybody, all you very important people here. Thank you. And thank you to Vice-Chancellor for your kind words. I am absolutely delighted to be able to give this inaugural lecture. It does feel odd being a professor here, or a lecturer, certainly have been here, a professor for 4 years, having lectured here for more than 25. All right, I was a student here. My dad was a lecturer here. We used to go to the gym when I was in primary school. All right, I don't feel very new. So in honour of the occasion, I thought I would prepare something new, something that could illustrate the value of my research, and something I hadn't already talked about before. And of course, as most people here didn't know what I'd talked about before, so I could have just used something old. And I was like, that was really smart, wasn't it? And everyone will know that, the people around me will know how smart that wasn't. But that's okay, I did it anyway. So an inaugural lecture is typically divided into thirds. The first part's got introductory comments that might explain something about me or explain the influences. The first thing is about influences that explain the choices on my research career. The second's about the overall trajectory of a career, maybe an arc of how all my bits fit together, and then the third is a specific example from the overall work, something that you might be able to take away. You might have learnt, something, say, about law. But it does have to be aimed at a general audience. I know at least one person who says very endearing things to me, like, you're not going to talk about law, are you? But that's okay, I'm still grateful. The first part, about the various life influences on the trajectory, and I've got that divided into 3. Things always come in 3s, you know that. There's the childhood or upbringing, study and early career in my 20s, pretty much, and then current family. And the problem with current family going, what do we do? All right, so I think family is always first, past and present. And a number of people here did know my parents, even more knew my father, as he taught philosophy, as has been mentioned. I am going to go out on a limb and say that we were, about as hippie as you could get for someone who had a job. But I've been told he did the, quote, hippie philosopher thing very well. Long hair, little leather headband, a bushy ginger beard, bare feet, until I was 13, and his research focus was, of course, ethics, right, particularly the philosopher Hume, and I believe. Okay, so my mother had an afro, Not a good photo. I couldn't find a good one with the afro and everything, but it was sometimes longer, sometimes shorter. You can't really see all of the hair, but Mum was apparently very different, a people magnet with the X factor, and for whatever reason, we always had a steady stream of people in our house, particularly for dinners and parties. Also working bees was a big thing, 70. Picture an old double bay villa in the middle of Karori, a large bunch of men and women on top painting the roof, and everybody's topless. And it's like, damn hippies, right? So both my parents emphasised service and helping other people. I recall that our very own Roger Clark was part of the group that started the New Zealand branch of Amnesty International in the mid-60s. Dad came back, we were in Oxford, so we got this gown, Oxford for his PhD. We came back in 69. And of course, he then joined Roger and others, proceeding to write things for them. There was a publication on torture, and I know I have it somewhere in a box, but I couldn't find it easily, quickly. But we've got I found the, the library catalogue record for it. He was also, this is while he's a lecturer, right? He was the chair of the New Zealand Foster Care Federation. That's the pic from the Dom Post. From 75, I believe. I didn't write that down. And lots more media and writing appearances. There's an interview here. And paper from conference every year. They've got a philosophy or foster care conferences in the school holidays. So we also had a lot of foster children. In fact, back in that first slide, had piggybacking one of our foster children, Keith. And we had quite a few that seemed to me as a child seemed to stay for very lengthy periods of time. I was out collecting on weekends for Corso, or any NGO with a good cause, right? Back in the days when everybody used cash and primary school age children were allowed to go collecting for it. Right? And we apparently had one of the few openly socialist households in Karori. I didn't know that. I knew we stuck out like a sore thumb, but that was about it. I did spend a few years at Ngāti Pōneke. My parents were good friends of Donis and Bill Nathan. We spent Saturday mornings learning te reo. I even went on tour as part of a haka group. But you can see I did stick out like a sore thumb. Even my pew-pew's white. All right. So why do I mention all this really early background? Well, partly because today it's not so common. It's not the same we have a different mindset that kids learn nowadays and grow up with, right? Partly it's also because there's lots of people here I know that know my parents. And I thought that's something that resonates, or were doing the same thing at that time, right? But also, like my parents, certainly my mother passed far too young, but both my parents passed already. My mother when she was only 33, and then my father when he was 56. So I've outlived both of them. Right, so that was normal to be, but I think it influenced my choices for research and career as well in three ways. One, it was normal to be a university academic. Lots of our friends were. Standard conversations, with philosophers in the kitchen that I would sit and listen in the little side bit. They were normal to argue and have big ideas, and I see Fiona smiling brilliantly because she was one of them, right? And more importantly, it's normal to argue what's a good reason for something, right? For anything. Doesn't matter. You've got to know whether you've got a good reason. But then I also think third, it's that duty of those who can to work to address social justice, right, where you can. Māori and environmental justice were certainly both part of that in the 70s growing up. At the time, there'll be a lot of people who remember this and a lot of people who have no idea, right? But at the time there was quite a strong political divide on social and environmental matters. Despite Earth Day, top left, there were fights over Lake Manapuri, think big projects, huge infrastructure projects, it's been in the news. Oh, this is like Think Big again. I know people don't think it's quite the same, but we had that same kind of divide. Same in relation to Māori rights, Dame Whina Cooper and her land march. All right, the establishment of the Waitangi Tribunal in 75, Nader Glavish's Kia ora, where she was basically pretty much fired for saying Kia ora, as a phone, receptionist? yeah. There were strong opinions both ways, yet I'd still describe the overall theme of that time growing up in a household as well as the country as peace, love, environment and human rights. When I was at law school in the 80s, Longi came in, but it was really important for law, legally, the Huakina case, I don't think I have got them up, yeah, the Huakina case and then the state-owned enterprises case, two huge decisions in terms of Māori rights that, changed completely, certainly what the country thought about this legal effect of the Treaty of Waitangi. Right, its principles and its effect in statutes. It was really exciting. I was a student at law school, and then I remember when these were handed down, within 4 weeks, I think one was the 2nd of June and one was like the 29th, so 4 weeks apart. And both did, I'm not going to go into what they did do, but I remember my first job at in the Law Reform Division at the Department of Justice, having a brainstorming session on what we could do with these cases. And I do know it influenced drafting at the time. So that brings me to another theme of my trajectory. When working somewhere like the Law Reform Division, you don't specialise. You, at least as a graduate, but I worked on privacy. I invented those lovely information privacy principles that came out in the 1993 Act, right? I still remember that eureka moment. I worked on the Bill of Rights that we also got, family law, the new RMA, we have that too. But notice they're all completely different areas of law. You'd do that in public law, family, environment. Nobody today would span all of those, yet when you work in these departments, you're expected to be across all of them. Right, so once I was asked to do something on criminal law, and I was like, what? Criminal law? I was hesitant. But I was told, no, you have to. It's a core area of law. Everybody's got to do that. It's fundamental. Everyone's got to do criminal law. You had to be able to work on any topic. Next was my master's degree. Yeah, that's okay. My master's degree, just looking for a seat, right? Just squeeze in. So I jumped at the chance to do a human rights fellowship, working on international law of indigenous self-determination. I visited the UN in Geneva, observing the working group on indigenous peoples. It was called populations, but we can call it peoples. Then moved to Australia to take up a teaching position on international law, one subject, Aboriginal rights, and the other on helping out with environment. Taught international environmental law, and all of that early scholarship was about improving, indigenous rights in law, and mostly international law. We returned to Aotearoa when we had our first child. That's the pull of whānau, and I really mean whānau, the wider family, all those aunts, uncles, cousins, close family, friends, everybody, you're all the draw cards. To come back to Wellington, despite the weather, right? we thought about it. I quite like the weather in Australia, we came back, and I do here have to pay special tribute and mention to our dear Aunt Isabel, who played a big part in our lives then, and also left us far too young. So having children has actually been a huge part of who I am today, and for that I'm eternally grateful. They've certainly made life a lot more fun and more real, and it's not that one. Okay, I forgot to put on the Yale and the graduate slide. That's right. So this was actually, I know it looks stupid because it was a video that I took tried to take a screen still of, but this was them. They got a slot on the TV1 News, right? They had like a 5 or 6 minute article about them on the TV1 News, and yes, they were monkey boys. So it won't be a surprise to other parents to hear, right, that having children has had an impact on the type of work they've done. Right, my first teaching here was actually international law. And I'm not doing that now. You might not know that. Professor Alberto Costi, that was before he came in. That was to fill in for Bill Hastings. I don't know how many people remember he went off to be chief censor at short notice, I gather, and I got asked to teach it. As a new parent, that was actually new with the second child, I had already found I wasn't able to travel quite so easily, do the international law. That made it really hard to keep up with the research and the conferences, and especially when I'd been going to international meetings, and my writing, I'll talk about in a minute, has been very much about observation and comment. All right, so I thought, I better switch to domestic topics, and so I thought, I'll do just domestic environment and domestic, and I wouldn't have to travel so much, right? So I switched. Back then, 95 to 2010, right, I did not feel like I had a research trajectory, I can tell you that. 2 maternity leaves, about 8 years part-time, young children. I did feel, honestly, that I spent most of the time running around after monkey boys who didn't like to sit still. They're doing really well now. But I did learn really quickly to explain things in a way that they could understand, knowing what they knew from their perspective. It's like I knew everything that they knew, pretty much. So I used that skill in my teaching here, explaining by putting things into terms that, and a context that students would know. Of course, for every mum, there comes a time when their generous and well-meaning explanations become just so annoying. Right, like the eye roll, why are you still talking when I stopped listening ages ago? How many parents have received this text? I've got this more than once. I know I'm not alone. But I mention it now, not to make fun of the kids, but because I actually think it's really important to reach the generation who wants, or anybody, there's just too much information out there. You don't have time to read everything. I feel like I don't have time to read anything, and I like reading, right? Actually, it's really important as part of our research and as part of our role, and especially if you want to achieve change, to reach this TLDR generation. And, writing another 100,000 words is not usually, or not always, going to do that. So I actually regard the TED Talk I did in 2015 on my research to a human right to healthy environment as really valuable, quite apart from family reasons. I won't go into that. But there were around 1,100 people at that TED Talk. I was asked by a good number of them afterwards where they could sign up for my movement. And I'm going, oh, yes, that's a great idea. But no, I don't have a movement. I probably shouldn't. As a professor, I'm a card-carrying paper piler. Right? If you want organisation, you might need to get me a PA. Right? But I've always been happy to help, where I can. I'm not going to list them all, but I have helped schools, some of our graduates, community groups, hapu, iwi, sometimes with general skills, but also sometimes explicitly applying my research. Just as an example, I was one of 3 academics that assisted Ngā Rauru pro bono as an academic with their submissions to the EPA Board of Inquiry in the Trans-Tasman Resources seabed mining application. I've drafted 2 treaty claims and provided background research into some novel potential avenues for addressing environmental justice. I've sat on quite a few voluntary boards, from primary school, to 350.org, ECO, Amnesty International, for the Aotearoa New Zealand branch. I'm currently on the international board for the International Union for the Conservation of Nature, IUCN. I don't know how many people know that. It's actually one of the largest environmental organisations in the whole world, but we don't see them here because they do most of their work in non-developed, in the developing world. We are more of a contributor to their work. But I do also chair their task force on Antarctica and the Southern Ocean, and have been a commissioner in the Toxics Inquiry, pesticides and nasty chemicals that you don't want near your body, or breathing them in, right? So, and yes, I've been an advisor to the Environmental Law Initiative, love that organisation and those people, mostly on law reform matters, but also ideas for legal challenges. So, is there a theme? Is there a trajectory theme? Well, I do. One of them I suggest is service. Right, a service that was, brought up, probably learned in childhood. And one of them is the arguing about ideas, words and ideas, full explanations, of course, but not a lot of specialisation. Right, so that does lead me. So there's all sort of the influences that lead to the trajectory. So I don't think my trajectory looks at all like any of the other professorial inaugurals that I've attended. Certainly in other disciplines, you get someone who chooses something early on, maybe like for a PhD, and they've been doing that thing ever since, whether it's Nancy's ice core drilling, or looking down microscopes at pictures of crystals and trying to figure out what they're doing. Most recently, Dean Knight in his inaugural lecture on judicial review, I thought that was really focused, right? And I'm going, I don't have any focus. I'm not sure there's any one thing that neatly describes what I've been doing. And it was Nick that came up with the Renaissance, and I go, I'll take that one. I'll take the Renaissance. I think it's partly the nature of the law degree, right? It is skills-based. I was told in my first job, you need to be able to apply it to any topic. So what have I done? Hung hundreds of presentations, not talking about my lectures, there's many more hundreds of those. I've written about 88 refereed publications. I think 69 are sole authored, and some of the research reports, some of those sole authored ones, not all, a lot of them are joint, but some of them have ended up the size of PhD theses. So goodness knows how many projects are still, like, mostly written. I'd like to say they're in a drawer, but the drawer's only metaphorical. They're most likely to be in a pile somewhere, maybe in a box stacked somewhere, like my old office. Don't tell Carol. So I've written quite a few articles. So in terms of the types, right, I've written quite a few that are based on observing debates, just identifying patterns, creating frameworks. I then use the framework to classify what I've seen. Right? I love doing that. I love putting examples into diagrams or a matrix. I like paying attention to figure out where people are coming from. What do they say when they use these words, or then they, especially when they're arguing? I ask why a lot. Some people find that really annoying, but I have found it gets sort of, a whole nother layer of that figuring out what people are meaning when they're talking. So in law, I might wonder, what tools have you used in your statutory interpretation? Are they the right ones? I'll come to that in a minute. In environmental protection, you might ask, what approach is that? Is that anthropocentric? Is that ecocentric? Where are the other species in this decision? Is that all about people and their needs or greeds? Right? So I do try and stand outside and look at the big picture. While to do that, though, you often have to get into the detail and create those frameworks and figure out where things fit. So, yeah, total renaissance, trying to put it all in a big picture, but also you have to know all the examples. So in terms of research types, I'd say I spend a lot of time in synthesis, but also discovery from observation. And so there's not a lot of, people don't think of law as being about discovery, but it can be. Right. Most people think that's science. So I'll illustrate some of the different projects with examples in my writing, and I thought what I might do is go take photos of all the front of them. I just didn't quite get around to it, so I didn't realise you'd be staring at this slide for so long, sorry. But in my article, I've got one, I did one in 92 on challenging state sovereignty. I wrote that as a Yale Human Rights Fellow. I started with observations from the debate at the Working Group on Indigenous Peoples. I saw how the states and Indigenous peoples were effectively talking past each other when they used the word self-determination. They were literally describing different things. I felt it was like a Joan Metch moment, almost anthropological. So I described their positions. I explained the different perspectives on the law. I figured out what I thought the law actually was, right? And then I just wrote it up. Other people found that really helpful. It still gets cited and it's been excerpted for anthologies. So that's, again, a type of knowledge creation. You observe and you document and you try and analyse. For an article for UCLA on Indigenous rights of democratic participation in international law. So in international, you've got different areas, different areas even of human rights law. Right? And so you've got an area, say, of Indigenous rights, you've got an area of women's rights or children's rights, you've got, say, political rights. I mean, now you've got an area of human right to health, but often different people work, some people specialise, and some people work on just those areas. And I was reading all the cases and thought I was going to write this particular article, and as I'm reading the detail, I realise that these two different areas, the Indigenous rights, the area of Indigenous rights, addresses political participation. The area of political rights and participation addresses Indigenous people's rights. And they said completely different things. So I simply pointed that out, and no one else had noticed it. So, again, it's this, I feel like it almost didn't matter what the topic was, because I just like noticing those kind of things. Of course, I took 72 pages to do that, but that's why you publish in American law journals. As long as you have enough footnotes, you can have as many words as you like. So another project in that vein could be my 2017 article on environmental justice. I noticed the American debate on environmental justice, and it's a huge debate in the States on environmental justice. It's race-based, but it ignored Indigenous concepts and Indigenous people's requests for what they considered to be environmental justice. So that's a huge omission over there, and I just figured out a different framework, a way of looking at it, and illustrate it with case studies to show that my framework was more useful than theirs. right? Then one, 3 elements are better than 2, right? So I really enjoyed those big survey projects. Here in New Zealand, I did undertake, with the courtesy of a very patient law foundation, a big survey of hundreds of Court of Appeal cases, trying to identify patterns in how judges use parliamentary history materials, and that's in their decisions and judgments. And then, do they have any rules? Have they figured out, or are they saying they've got rules, or do I have to figure out the pattern myself and say, this is what I think they're doing, right? I didn't really care about the substance of the law. It didn't matter what area of law, what statute they're interpreting. I just wanted to know the method. And I've written that up. So another paper surveyed the use of Māori words in legislation. That was back in, I think it was 2010, somewhere back then, before I went on sabbatical in 2011. But it's I guess that type of thing is what I'm doing rather than a subject area so much. The examples I've given are mostly indigenous, but I've done it in environmental law, but most of my environment ones have actually been some of my articles have been fairly standard. I might look at the science and then say, how is the science reflected in the law? And I certainly did that on my article on pesticide regulation. It was 2018. Pesticides are one of the toxic chemicals killing our natural world. Footnote, we should refuse them. We should buy organic. But possibly the one with the biggest breadth is still in progress. That's taken a huge look at science modelling and other research on 11 different environmental topics. Again, it's the big picture, make a map, see where they fit, right? And focusing on predictions for 2050. I know I've given already some talks on that, but and written some of it up. I just haven't done anything with it. It's sitting in the drawer, that one. It definitely joins a lot of dots. So you might be surprised to learn that there are any topics that I've published on more than once, right? But I've written a couple articles on statutory interpretation, just a couple. Legal personhood for nature, maybe 4 or 5. Co-governance, climate adaptation law, and the precautionary principle, environmental law. That's one that I've actually worked on across a lot of statutes. Probably taught it more than I've written it, but that is one that's woven its way throughout my work, throughout my career as well. And I'm going to come back to that one in a few minutes. If there is 2 themes that keep coming back, and one of them would be statutory interpretation and the precautionary principle, and then obviously keeping a focus on indigenous rights. So I do want to offer 2 illustrations now, one on statutory interpretation and then precaution, and then I'll get to the case eventually. So, I didn't choose the skill, statutory interpretation, I think it chose me, right? This is lawyers and philosophers' bread and butter. I tell students that a law degree doesn't teach you really sort of what to think as much as it teaches you how to think, and especially about how to argue and argue about the meaning of words, right? It doesn't matter what the conclusion is. The point is to get the right method, and you need the right reasons for your argument. Does this sound familiar? Right? And the right evidence. And they only come from a good method. Why do we have to teach people how to figure out the meaning of a word? Don't we do that naturally? The English language, as we know, uses words in a lot of different senses. But think of a dictionary. There's more than one meaning. You look at one word and there could be 6 different meanings. Okay, so how do you know which meaning is the one that got put in the statute? Right? So, just taking an easy example, the word animal, right? There's more than one of those. If we have an Animals Protection Act, animal welfare legislation, we probably don't expect that to cover humans, do we? But aren't humans animals? It's one of the meanings in the dictionary, right? We get literal arguments, and it's one of the literal meanings, isn't it? So we get literal meaning arguments like that all the time, but you can't say, I'm just being literal, because there's more than one literal meaning. Right? So you could go the other way, right? Are insects covered by animal welfare legislation that protects against causing, harm or unnecessary suffering? How about flies or cockroaches? Right? Are they covered? Do we just not worry about enforcing that? Or do we actually think they're a different group of creatures? They're included in animal as well, right? And one meaning of animal. So I really mention this, the lawyers know this already. So I mention this more for the non-lawyers in the room, simply to stress that the meanings of words depend on the way they're used And that means they depend on their context and the intent or the purpose for which you're using them. And then that goes, especially when they're put into statutes for a particular reason. Sometimes words are defined in a statute, but mostly they're not. So statutes are written in ordinary words that we're meant to be able to understand. So we devised rules, right, about, this is law, devised rules about what you can look at and what you should look at in order to determine the meaning of words. It's not a free-for-all. In the first year course, in Laws 1, 2, 3, we teach students how to precisely identify what it is about the meaning of a word that doesn't seem quite right in a fact situation, like whether a rule in a statute applies to it. And we also have an 11-point process for figuring this out. I guess the first 3 are identifying the issue. That's not really part of the 11 points. But the last one has got 4 included. So you could say it's a 12-point process. I liken this, and we make students go through every single one. You have to learn how to do each one, right, properly, with the right reasons and the right method. I liken it to the snowplow approach for learning to ski. Right? You get taught, when you first learn to ski, you get taught a particular approach that when you get good, you'll never use again. Unless you get into trouble, or you hurt something and then you have to revert back to basics. All right? So I mean, you could think of it as training wheels on a bicycle as well. Once you get good, you don't need your training wheels. But we make students do every step. They're not always relevant to solving each problem. In fact, they'll never probably get only in an exam, right, where we test them, will you get every step relevant to a real problem, But if you try and skip over them when you're not good at them all, then you'll come a cropper, right? Only when you master it can you progress to jump turning. So experienced lawyers and judges are jump turning skiers. And quite rightly, they skip over the steps they know they don't need, okay? But it's not helpful if they miss ones that actually help them solve the problem. For example, we don't want them to completely miss looking at the purpose of the legislation, do we? Especially if there's evidence of that purpose that helps them solve the problem. But even experienced lawyers don't always get those jumps right. Within the last 2 years, I couldn't remember the exact year, and I just didn't go back and look, either last year or the year before, I've seen a publicly available opinion from a large law firm that's interpreting a noun in the RMA, looking at whether an unexpected fact was included in that noun. It only looked at the dictionary. Only step 1. It was signed off by a partner in that large law firm, honest. So I can understand why the High Court might say you don't go looking for, say, meaning in post hoc information papers put out by the Ministry for the Environment, but that doesn't mean you don't go through your steps. That one post hoc paper doesn't invalidate all the rest of the steps. Right? I mean, it's not all bad. Indeed, the best interpretation I've seen, maybe unfortunately for most people, is from Inland Revenue. They've got some great legal opinions. I'd be very careful if you to pick battles with them. So judges' approaches to interpretation, I'm going to say variable. Right? I don't think it's necessarily a personal method because there's one High Court judge, and again, I'm not going to name them here like public, I'm happy to talk about them, but one High Court judge has chalked up both the best and the worst examples of RMA statutory interpretation method I've seen. So I think it's not personal, but maybe it's the case they were given. Right? Or maybe they didn't get good arguments from the lawyers. You can blame the lawyers. The judges can always fall back on that. I didn't get the right arguments, and I'm not allowed to go looking on my own, right, if they haven't been given. So, but judges' decisions do have serious consequences, so they're meant to get it right. It's definitely much better. And I'm going to give one example, and this one everyone knows then who the people are, but I can do this because this is the Supreme Court. Right? So the 2013 decision, and it's maybe not the current Supreme Court either, but the 2013 decision of the Supreme Court in Bulla Coal, right, that allowed the resource consent to mine the Bulla Plateau for coal, and a whole bunch of snails died and all sorts of things. Right? It was a huge deal. It was also a split decision over the interpretation of the statute and its amendment. And in my opinion, only one judge, when I say split, that means different judges have different opinions, right? Only one judge got the method of statutory interpretation right. That was the then Chief Justice, the Right Honourable Dame Shana Elias. That decision, she was in dissent though, unfortunately. She was not the majority. That came out in 2013. I was talked about it in class in 2014. That was in environmental law. I never felt I don't know, I never felt able to just write it up as open criticism. I probably should have. I just wasn't as bolshy. Not as I am now. Anyway, I've thought of it. Did anyone go to David McLaughlin's lecture last week? He showed, I think I need to channel David McLaughlin. He showed how commenting on judicial decisions can basically be a blood sport. So this dovetails nicely into the discussion of the precautionary principle in New Zealand environmental law, because that's another one that typically entails interpreting a statute. And because we're getting to the case, it's one that was key to the Environment Court report on the water conservation. I say case, the Environment Court makes decisions in cases. This particular one was actually a report to the Minister. But of course in my head we say Environment Court, we say case. So excuse me if I keep saying case and not report, but I've clarified it. So what's the precautionary principle? Oh, this has got, okay. So the precautionary principle, I'm going to do one at a time. All right, this is from my class. This says that we can take precautionary measures even in the absence of full scientific certainty about the effects of our actions on the environment. All right? Quite easy, quite simple. We can act to avoid a threat of harm even if there's not enough evidence to prove causation or precise results. Why? Because once clear proof becomes available, it might be too late to fix it. And that's the old rule, better safe than sorry, stitch in time saves 9, that kind of. So it departs, though, from standard legal rules about causation, and so a lot of lawyers have difficulty with it. What it's meant to do, though, is maybe not be used as a sword, but it's meant to be able to be used as a shield to defend your decision, right? If I want to make, I'll come to some decisions. Think of fishing's in the news. Maui dolphins, Hector's dolphins, seabirds getting caught on hooks, everything, right? The minister could make a decision that says, you know what, I think we've reached the limit of those. I'm going to make a decision to either maybe ban some more trawling, some set netting, put some hooks on, or I'm going to make a decision that protects those birds or seals or whatever it is, be precautionary. And there's not evidence. There's not conclusive evidence, not enough for causation for a case, that you might win on, to say that, yes, that would happen if I didn't do it, but I don't need it. This is a shield that says I can take that anyway, okay? That's what it's important for. But, of course, they vary, because it's really a principle, it's an idea. The most common theme is literally this: states shall be more cautious when information is uncertain, unreliable, or inadequate. The absence of adequate scientific information shall not be used as a reason for postponing or failing to take conservation and management measures. But quite reasonable, quite normal. In the CBD, the Convention on Biological Diversity, they have one like that, where they actually use it as a significant reduction or loss of biological diversity in that convention. And it's the same idea afterwards. Obviously, management measures in one, measures to avoid or minimise a threat. Wording changes slightly, but same idea. The Rio Declaration Formulation 92, this is the lowest common denominator. It again applies to any topic. The lowest common denominator because all the states could agree on it. Right, and you know what it's like when you try to agree on something. You cut out all of the controversial bits. And also sometimes it's the weakest version, but that's okay. So this one says the precautionary approach shall be widely applied to states, though it adds according to their capabilities. Where there are threats of serious or irreversible damage, lack of full scientific certainty shall not be used as a reason for postponing cost-effective measures to prevent environmental degradation. So you can see that they change slightly, but the idea is there. So we have a Fisheries Act in 96, this 92 with the CBD and the Rio Declaration, and New Zealand goes, we should have a precautionary principle. I bet you someone like Geoffrey Palmer probably had something to do with it. But I didn't do fisheries back then, so I don't actually know what went into it. But then they went and drafted it in a really weird way. The drafters got and thought, we need to be a bit more precise than just this general principle. Let's break it down, make it a little bit easier for people to follow. So they go, it's only a principle, take into account the following principles. But they go, decisions should be based on the best available information. decision makers should consider uncertainty. You should be cautious when it's uncertain. And then, in the absence of information or uncertainty, and then you've got this shield as a defence, right? You can't be used as a reason for postponing a failure. So it's a little bit different from the others, but you can see the minister, when he introduced it, said this was the implementation of the precautionary principle. By the time it came in, this was national government, but yeah, it was said to be the precautionary principle. So it started off really well. Previous Justice Ellis in '98 applied it in a case which reduced rock lobster total allowable catch, and it was upheld as a precautionary decision, right? And then the fisheries companies started challenging that first one, that best available information, right? The one that said ministers should use, take into account the principle that ministers should use. And we actually had, squid fishery wasn't the first. We actually had a series of cases, because if I'm going to give the full thing on the Fisheries Act, that's like another half hour. So I'm not going to do that. But we had a series of cases that challenged these individual elements and ministers' precautionary decisions on banning set netting for, Maui dolphins or sea lions and squid fisheries. They all got struck down because there was something in the information that the department put up to the minister that someone else said, oh no, they should have had this. And the court goes, they probably should have. The only one, I was going to say, what I've done is, I've cut there's only, after Ellis, the only other judge that I think, again, got it right on statutory interpretation was Justice France, when she was in the High Court. So now she's on the Supreme Court. Anyway, so now maybe we should be trying to fix this. So just as an illustration though, there were models, one of the things you do, marine mammals like eating the same fish that we like catching for food, for commerce, and they often get caught in our nets, and then they die, and if we catch too many of them like that, then these species will go extinct much sooner than if we didn't do this, we weren't fishing. They have they set a maximum amount of fishing related mortality, and when you reach that limit, then you have to stop fishing. So of course the fisheries companies want a really high limit so they can keep fishing, and a lot of environmental groups saying, we don't think that's precaution enough. We know this is one of those ones where it will be too late. So a low limit was set on a model, and then someone said, no, you should have used a different model. They used the same model they'd been using for years, but a new one came out, and Justice France says, it's okay to be precautionary. You're allowed to do this. Court of Appeal said, no, you need to know the numbers. You need to know all the possible numbers. There were numbers available. You didn't give them to the minister. Go back and do it again. And you're going, we didn't even get down to D. All right? This is just A. You didn't use the rest available information. I think I'm probably spending a bit long on this, but I hope it's okay. But another case challenged Orange Ruffy. And I know there are some people who work for the law firm that did this. I don't know if they were involved. So D, which was the effect of bringing in the shield, right? So the Orange Ruffy quota was decided, the minister decided to reduce the total allowable catch, and it was challenged both on the information but then also purpose. They go, wait a minute, that D said it was for the purpose of the Act. The shield was only to defend the purpose of the Act. Our purpose of the Act has got two purposes. It's got conservation and fishing, right? And the conservation is often interpreted as sustaining the fishing. So, and they argued, I think this was Chapman Tripp, they argued there is no presumption in favour of preserving the resource for future generations. This is the utilisation of the fishery. And the minister was advised, oh shit, let's not defend this case. And they pulled it, we went to law reform and things. But I personally think, why do I give you these? I think they literally got the interpretation, they used the wrong method. They got it wrong, and it's had huge consequences, right? Ellen France knows how to do it. She still thinks she's right. I've asked her. So, ELI, where are you when you need to take a fisheries case, all right? Something needs to go to the Supreme Court on this one. But I was suitably outraged. I wrote an article in 2004. It was published in 2006. I gave conferences on it. It was back then. I got a little bee in my bonnet. I looked at Australian law, Canada law, American, international law. I taught a whole, when I taught international, no, it was environmental law, and I taught a whole half the course, just a week on each of these different parts of it. And that was one of those great things for classifying things in boxes and making frameworks. So I figured that's, I thought this is something I know something about. I think I should do some more of it, right? So I went and looked at the RMA. And that's something I also did in class. And took the Resource Management Act cases that used precaution, tried to figure out what was going on. Greg Severinson's got a PhD now, but when he was a research assistant, I got him to research some updates for me. And then he helpfully put them on a PowerPoint slide, which I'll show you in just a minute. But there's something very different about the incorporation of the precautionary principle in the RMA, right? First, it's actually not in the statute. It's a general principle of environmental law. So, can courts use it? We've got a statute, can they just bring in these general principles? There's the first question, and if so, how, right? But here's the funny thing. Different judges have done different things. This is Greg's, I think, very helpful slide, even though right here it's a bit bright. The judges have done different things ever since they've been putting it into this, ever since they've been taking cases on it. I'm not going to go through what all the words mean, sorry, don't read all the words, this is just an illustration. The yellow cases are one line of authority. You get the McIntyre, and then all these other yellow ones follow McIntyre. Shirley Primary School is another one. It takes a very different approach. And then all these other greyed out cases, they follow Shirley Schools. And they're all completely different. And then they do it in different ways. Some look at it as a burden of proof, some look at it as a standard of proof, and some say this is a general principle that comes into overall broad judgment when they had that. Right? So that doesn't mean much maybe to most lawyers in the room, but just take, most non-lawyers, sorry. But I hope it means something to the lawyers, but it really is just showing that different, when you don't, maybe when you don't know the whole picture and the framework, or you haven't had the right arguments on the principle, you actually don't know what it's meant to do. Right? So obviously there were different fact situations involved, and they did what they thought was the most sensible way to resolve that problem in front of them, which is what judges do. But it's not helpful for developing a framework or enabling other people to follow what you've done if everyone's got different things and they don't understand it. It is clear now that the precautionary principle is inherent in the RMA. It's inherent in the definition of effect, a potential effect there, and in the direction on how courts should be considering consents for those who want that. That's Section 104. And the Supreme Court has got guidance on how it might be applied, when you might want to decline an activity. Response depends on the facts in question. But think about a lawyer making arguments in court if they want to use it. You're trying to present your case or your client's case in the best way, persuade the judge that you've got the right. And one way to do that is, I've got some precedents on my side. And you say, look, I've got a whole line of precedents on my side. I'm going to pick the yellow ones. You might not even notice the other ones and might not realise it's a whole different way of looking at it because you've found like 20 cases that support you. Which I can totally understand. But I do think that has led to I don't want to say it's a blind spot. There are people who know more about the RMA here than me, and they know more about the practice of the RMA. I'm just the nerdy one who gets to write about, the rules. Right? But it did really make me think that practice needed a bit of academic assistance sometimes. And I know the academics need a lot of practical assistance, but sometimes I think the practicing people could help with some academic. So that brings me to the third and the last part, to Waikoropupū Springs. So how did I get involved in this case before the Environment Court, these sets of proceedings? Right, it's not a normal case. The precursor, that's why I've got here, is Magnolia Lowe's. Brilliant, very good. She made a really good documentary about my work, and I'm the haphazard thing, and she made it look really good. Right. That aired in May 2020, late May 2020. Kevin Moran saw the documentary, and he simply cold called me to be the lawyer, right, for their NGO. His NGO called Save Our Springs, to help protect Te Waikoropupū Springs in the Environment Court. And I thought, oh my goodness, that is exactly what I want to do. It seemed like the perfect marrying of academic and practical, all in the service of environmental protection. I did have to overcome a couple of hurdles, like, oh, I need a practicing certificate right now. So that wasn't instant. So I got my barrister brother Stephen to file urgent filing of proceeding. Apparently, and we didn't know this at the time when Kevin came to us, he had like 1 week to file a response. I don't think Kevin knew it either. But then I know I needed a senior RMA lawyer to take it on, so I called Sally Jepp. I knew Sally knew what a good argument looked like, and of course I could, there's a lot of people I've mentioned there. I had to take out, because I had it too long, I had to take out all of the extra paragraphs. I've got another 3 pages, maybe I'll use it at morning tea tomorrow, about all of the stuff about the people and the thank you. But anyway, I'll just talk about the stuff. So, what was Te Waikoropupū Springs about? Well, under the Resource Management Act, RMA, there's a Part 9 which enables the Minister for the Environment to make water conservation orders. You don't have to read all the text, but it's like, I need visuals and I like seeing what's up there. They've been likened to being the equivalent of national parks for water bodies. Right? So, and you can see the Section 199 has got a purpose of a water conservation order. It's to recognise and sustain, there's A and B, outstanding amenity or intrinsic values which are afforded by waters in their natural state, or if they're not, maybe they've been degraded, then they're values which warrant protection. And then it can do all these other things. You can preserve it as far as possible in its natural state. You can protect its characteristics, which I consider to be outstanding, and there's a few there. Habitats, fishery, wild, scenic characteristics, scientific value, recreational, historical, cultural, or spiritual purposes. I just reversed those. And if it's significance in accordance with tikanga Māori. So in order to protect the water body, the water conservation order can put in, it can make things mandatory. Some things it can't do, it wants to leave to maybe a regional council to do. But it can set some limits, some parameters. It might set limits on water flows, right? Or maybe allocation if you want to irrigate from somewhere. It can set, water quality limits. You can put restrictions on temperature and pressure, like from discharges, all sorts of things. And there have been a bunch of really significant water conservation orders made, mostly for outstanding wild and scenic rivers. But there had never been a water conservation order for an aquifer, one underground spring. But then there had never quite been a water body like Te Waikoropupū. This is a picture, actually, and I thought, there are pictures in, it's not officially a judgment, it's a report, but there are pictures in this report, which is like an Environment Court judgment. This is one of them. First, respect must be paid to Huriawa. She's one of the 3 main taniwha of the whole country, Aotearoa, and guardian of Te Waikoropupū. She's believed to rest beneath the surface of those springs and guards them, but she guards them from the mountains all the way out to the sea. The Wharepapa Arthur Marble Aquifer is part of a highly complex and vast karst hydrogeological artesian system. That karst system and the Takaka River and its tributaries all feed this spring. It's the largest cold water springs in the southern hemisphere. Every second, between 10,000 and 14,000 litres of water are released. Every second, and it's this constant boil, right, a huge upwelling. And you look down, and it actually doesn't look very far. It looks maybe 4 or 5 metres. It's actually about 15. It's huge, right? It's one of the clearest fresh waters in the whole world. 76 metres clarity. You can see 76 metres down. I think I can't see 76 metres without my glasses in the air. So, Anyway, that I believe it's second only to the Blue Lake, Lake Rotumairi Whenua, which is Nelson Lakes National Park. So very similar, right next door. So some of the clearest water ever measured, wonders of the natural world. That's the Dancing Springs next to it. And I just put the map. You can see the one on the left has got the hills with the native vegetation and then the cleared plains. But on the right, the red circle is the recharge area. So there's a big recharge area all the way up. But how does that water get so clear? Right. Oh, sorry, forgot. I had the schematic cross-section. This shows the marble, that huge, great big block underneath, right? Solid marble. And then you think, wait a minute, how does water soak through marble? There's apparently a lot of fissures, as in FISSU, fissures and cracks and channels that the water has carved over the years. That's most of it, but I'll come to that in a minute. So, but how does the water get so clear? It's the unseen. Right? The little stygofauna, creatures that eat any plant or other carboniferous material that washes down the water, they basically keep the water clean. So if we want to keep clean water, we have to keep these guys alive. But for Ngāti Tama ki te tauihu, te Aotearoa, and ngā rārua, te Waikoropupū is one of the most sacred places in Mōhua, Golden Bay. It's a registered wāhi tapu and taonga tuku iho. And they give it the name Te Puna Waiora. It's a spiritual and physical source of life. So the evidence is, lots of evidence that went before the court. These springs are awe-inspiring. They're spiritually significant for everyone, not just sacred to mana whenua and kaitiaki. Though non-Māori regard these as a very spiritual place. However, monitoring data, primarily gathered by Friends of Golden Bay, it's an NGO, showed that nitrates in the springs have been increasing for a number of years, right? Yet there were different views about where these nitrates were coming from. Many farmers wanted more irrigation, and with water quality dropping, there were many others very concerned for the health of the springs, worried that it was farming that was causing the nitrates, and also worried that, like other places where you've got nitrate levels, there may be another 10 or 15 years of a bulge still to come. And it's already going down. So there's big worries there. But that was disputed. We've seen it's a huge aquifer. You see the recharge area. The water comes in from all sources, up the hills, down the valley, from the national park, from farmland. That's just simplifying it. And then it seeps underground, right? But some water, some places it goes really, really slowly, and some places it goes quite fast. It's shallow. So some of it, and then, but a lot, pretty much all gets channeled up, or no, not all, sorry, bits of it get channeled up into the springs. Most of it goes out to sea underneath, right? But from isotope dating, apparently the water that comes out at the springs ranges from 2 years old to more than 100 years old. And an average, I recall, of about 8 years they were using. So, but obviously if you look at any particular water, that it would depend on, where it came in, as to how long it took and where it came from, what it carried. So the Tasman District Council had expert scientists who developed and used models for what they thought was happening to the water flows and where the nitrate was coming from. This did not suggest it was largely from the farming valley. They thought it was coming actually from elsewhere, particularly outside the national park, gorse and other things like that. The applicants for the water conservation order in this case, which I'll come to actually, but many others simply thought that beggared belief, given the history and the trajectory of the results of the nitrate levels. So what did they do about it? Well, Ngāti Tama, ki te Waiponungu Trust, and Andrew Yule, a retired scientist in Golden Bay, they applied for a water conservation order under the Act, under Part 9. They were using the brilliant Marie Baker Galloway and Rosie Hill at Anderson Lloyd in Queenstown, and that went to a special tribunal which reported in early 2020. I'm missing out all the procedure stuff in between. That special tribunal recommended a water conservation order, but with some discussions and findings that basically everybody disagreed with something in it. So then they went to the Environment Court, and that's what Kevin and Save Our Springs wanted to do. It's like, we need to go to the Environment Court now, so now we might need some lawyers. There was some attempt at mediation, expert witness conferencing, and that was in 2021, but eventually it had to be resolved by the Environment Court, and the hearings for that were in 22. There were a few issues, but fundamentally, I'm going to say 3, because I'm simplifying this, right? One was where the nitrates are coming from. That was a big issue. What was the maximum level that could be set for nitrates in the water to protect the springs? And what was the maximum available of water? This huge system, with rivers and aquifers, and farmers have got boreholes going down into the aquifer, right? what was the limit, the maximum amount of water available for irrigation. So those three, I'm going to say they were the three broad big issues. The source and limit was for nitrates were particularly important because that would then determine who had responsibility for making the changes. Right, and then, yeah. So I'm not going to summarise the whole case, then it wouldn't be inaugural, that would just be a lecture, right? So I'm just going to pick those three things that I used my research for. The statutory interpretation method, the precautionary principle, and then the use of tikanga to help interpret words. So on statutory interpretation, one debate was over whether the words protection and preservation in section 199 needed to focus only on preserving a current state. Remember they talked about preserving and protecting waters in their natural state. Is that only current, or can you contemplate improvement? Right? To protect something, are you freezing a state? If you choose a lower nitrate limit than what you've got now, because you say, oh, it's a bit high, we need to go lower, are you just improving it? Are you allowed to do that? And that's actually an issue that on the words of the statute you go, oh, damn. We need to argue about whether you're actually allowed to even set a lower limit, right? So that's a legal issue about the permissible interpretation. And in one sense, it's an argument about whether to take a narrow literal meaning of preserve and protect, that's freezing a state, or an expansive, maybe purposive contextual, this idea of you're protecting the qualities of the springs, and that might mean improving them. So you can see how one word can have these two different meanings. So we have rules now, that we had them before, different act, but the meaning of legislation, this is a rule everyone has to follow, well, certainly all judges, must be ascertained from its text and in light of its purpose and context. And so ascertained from the text, that might be the dictionaries, how we just use the words, but then what was it trying to do and what's the wider context? And then we have also another section that said words must be applied to circumstances as they arise. And you go, yeah, and? Right, no, this means basically that words must simply be kept in step with the times. I mean, a really simple example, sometimes it's called an ambulatory approach, that was one of the steps on my slide, but a really simple example would be, think of the word vehicle. You can have the word vehicle in Act, and 20 years later it means something, it covers a wider range of things than it did when that Act was passed. So they weren't maybe envisaging all those new fancy things that we call vehicle later, but can we still include them? Yeah, because the word has expanded its meaning. You apply it to same word, different ambit, you might say. So ascertaining a meaning is not just using a dictionary or applying just a precedent, but you need to consider the application to the current context and the policy and purpose, right, of the legislation as it is now. The only previous decision that faced that or that considered that interpretation issue about preserve and protect was from 2004. Right, and they decided on a narrow current state answer. But they had only taken a narrow look. When you go read it, I go, oh, what method did they use? They only looked at dictionary definitions. You go, oh, we can do better than that. And we can say they're wrong, right? So no consideration of purpose, and today we've got this. I mean, they had that back then as well. Someone should have told them off back then. But there's certainly no suggestion that you could only do that. You had to look at these wider things. So we did. We provided that information about the legislative history, the purpose. We referred to the current context of fresh water here in Aotearoa, the state of the last 20 years, and the changes and the new mechanisms that have come in to protect it, and the requirements on councils to be following, like Te Mana o Te Wai. All of that context can be taken into account in applying words to today's circumstances. So then you choose an interpretation that best uphold it and the one that's most consistent. So in this case, if any water body in Aotearoa could be justified being returned to its pristine state, it would be this water body, wouldn't it? The clearest fresh water in the world. So another way to look at the interpretation and that definition of current state is tikanga. Remember the status of the waters as te puna waiora. Maybe we're getting too technical and making a distinction between a slight scientific degradation. There's only two, nitrate and E. coli, and there's a long list of water quality indicators. So there's only 2 out of a long list of, say, was it about 9? If only 2's degraded, can we maybe give it a general label and still call it in its natural state? If tikanga suggests that it's still tapu, they're still sacred, they're still natural waters guarded by huriawa, they're still in their natural state according to tikanga, right? So can we use that to help interpret the terms? Well, it was great timing. The Environment Court asked lawyers that. Great timing. We just had Supreme Court decision in Trans-Tasman Resources, which used tikanga to do exactly that, a statutory interpretation tool. And it was also very topical with the Ellis case and changes to legal education. But as a result, I taught it in RMA. We'd had Justice Cooper give a presentation at the law school. I think Jeff McClay hadn't yet given his on that. But I was able to give not only the TTRL case, but also the other cases before it that supported using this. And yes, the Environment Court did take the meaning of waters in their natural state that was consistent with tikanga, that enabled that wider, with that and the purpose and context, we're allowed to improve. We're allowed to drop the nitrate levels and try and improve those 2 elements and take an expansive interpretation. So, final bit is on the precautionary principle. In this water, you'll laugh at this. I don't have a watch or a phone on, so I have no idea how it's going. I only did a word count. That's okay. Over the window. And so I started about now. Oh, sorry, I'm actually out of time, aren't I? But that's all right. I'll give you the water concert. And that's funny. The Vice Chancellor said, "Oh, you can take as long as you like. This is your day." And I go. So I didn't know I'd have to actually use that. So I first noticed the inclusion of the precautionary principle in one of the parties' grounds of appeal. Right? Technically not an appeal, but, effectively and loosely. So I genuinely thought the way those submissions on precaution I thought it was garbled, completely garbled, didn't make sense, and I wondered if I was missing something, genuinely. But I thought, he's a really good lawyer, and I thought, nah, I'm missing something. Then I thought, maybe it's just that choice of selective precedence, and I could address that. Remember the different options. There was a lot of scientific uncertainty in this case, right? The biggest uncertainty, where are the nitrates coming from? The Tasman District Council had one set of assumptions. The applicants got scientists from NIWA and other sets and it took years of argument to try and resolve. And they didn't come to an agreement. The Environment Court resolved it for them, right? So that's best left to someone else to elaborate. All I wanted to say here is uncertainty exists. And also risk. We have risk. The sticker farming. No one knows what level of nitrates it takes to kill all those little creatures, right? You understand? No one would add. Whether the delay, no one knows if they're still down there doing their work. We get the water years later. So if we want to continue to receive that water, it seems this looks like exactly the kind of risk and damage that it brings into play at ordinary principle. Protect the other sea. So we had to argue first that we could do it in part one, because we haven't got a effect that is elsewhere in that statute, and then argue how. And given what I'd seen elsewhere, Fisheries Act, that's why I mentioned this, and then the confusion in the RFA, the only good swing out here is thorough. So I can. We detailed the overall purpose, the history, the assumptions we offer, the cautionary approach, explaining the different elements, threshold, threat, the amount of evidence, the type of action, what the Supreme Court said. What's on with that goal was how minimalisation. Explained how it had been brought in the RMA to date and tell us how it could and how we should be applied in this particular case. It was very academic. Someone's research got highly covering that column. And I thought it was targeted and not fulsome at all, not very academic. But just that I've used 15 pages, about 40 footnotes, and I was told that's quite unusual. The submissions. Did end up with 55-page submissions? Yes. And but they didn't turn us off. I think the line was one of the commissioners on the court said, when I saw it was 55 pages, my heart sank. But then I read it, and it was actually surprisingly readable. Oh, thank you. And it's not made this study as well, but it was worth it, right? But I think might be that. I think this, again, those submissions and the way
they assisted building a high point in my career because after we give them a little extraordinary instead of was in a summary, and one of the other counsel will insist him that its current species of the court. Would you say?
Good.
I can retire now. So all that nerdy research actually made the difference, right? The Environment Court found it possible to consider a precautionary principle, and they found it was essential to findings on nitrate. So what I did then was, I'm going to skip out this, don't read the edit, but what I got is all these quotes from the Environment Court about how we have to focus on the unacceptable harm, the ecological harm, and we have to do it in a consideration that I was precautionary principle. It's not appropriate in terms of the precautionary principle that additional allocations be made. You know, we set aside the so-called approach under the other cases. However, it's a principle in international law. We're going to follow these grounds. And in the absence of being able to rely the limits, you know, we have to do them to effect, and we acknowledge the full submissions from East to West. Right? So, that's pretty much all I have to say about the case. I forwarded that running. You might have noticed, see the number of the paragraphs? Yeah. There are 877 paragraphs in this report and 314 pages. That's what I did with the Environment Report. I got a breakdown if you want to know it, but I can just say I forwarded that to the Right Honourable Justice Trey Williams. In his reaction was along the lines of, good God. But please don't let the size turn you off the report, because an understanding of how these conclusions to reach is a significant decision for significant immunity. And I've only just touched the surface in what the 15-minute in this case. They are significant findings, there are other significant findings, I should say, and I'd be remiss if I didn't mention, because none of this here, the spiritual values. They found that the spiritual values were a significant characteristic of these springs, and it's the first time that it has been done, again, in the conservation order. And that's something that Kevin was the only thing really wanted. I mean, we parked to that was all that kind of stuff. But with the extra guidance, we'll agreed on it. So, in conclusion, right, in terms of research trajectory, I would suggest I've got a few themes, right? Gender ideas, too many words, too little. It's like, but seriously, and we just proved that, I did not. I did a word count that told me how many minutes it would take. It was not that many. So that's, now I talk fast too, you know. I think it's the extra bits that I had. So, the other one, it's laws about skills. Right? The skill of determining what the law is in statutes or cases, the skills of the law, method of topic. There's also the skill of ranking it, the words, right? And using wider principles. The method's good, but you also need to use concepts of justice, fear, promotion. And third, service. You will need to help with all the birthplace where we can. It's not quite that much, but could be. Just be positive service. But do that part. I will just have to note that I couldn't have done it without Sally Jerk. And no one could have done it without the Environmental Initiative or the Environmental Legal Aid Fund. They might do that just as we can. And of course, Kevin Marine and the Aotearoa Springs team. So there's that idea you can go the fast alone, but you go third like the team. So just going to leave you a last word for Ulia, that the entire to where them to cure it out there.
Thank you very much. And so, as you don't know me, my name is just played away in the acting gender and prophetic thing. And it's my professional honor and personal privilege to speak on behalf of my colleagues tonight to acknowledge Heather's career contributions, but also connection tonight. Before I do that, I just want to acknowledge people in the audience. I would acknowledge first, because I always like to do this, students who have come. It's a rare tribute. Students actually come to lectures all nowadays. Which one is not going to be at all examinable. But the fact that you've turned up shows us regard in which you called Kathy and the contribution she's made to learning. So I have to acknowledge that. Second, in relation to Kathy's friends and colleagues who have come along tonight. I know I shouldn't mention Sally Jebb, who I just had the privilege of meeting properly today, but I know there are other people in the audience whom she's similarly privileged to have worked with, that she is quite a bit of a mode with in professional terms. I also want to acknowledge Kathy's parents. I didn't know her mother, obviously, but this is a kind of full circle event for me because one of my very first lectures, maybe my first lecture at the university, was in fact John Iorns. And for a slightly conservative, maybe still slightly conservative person who mostly sees that issues, I did indeed find I would have used a little bit of empathy and emotion to your father. But he also convinced me, as many people in this room know, that my philosophical abilities are somewhat limited. And that I have certain as my career a less philosophically oriented subject. But I also want to particularly acknowledge Kathy's sons, Ruben and James. Anybody who knows Kathy knows how proud she is. And she talks of you a lot and how much she loves you. And I know this because she did something this year that no sane lecturer would ever do. She not only attended a student function that her son was DJing, but she descended into a place that no one should ever go, the moss pit of her. And what it's supported your son, and I think her own needs to imagine that she was actually still 21. I also just want to acknowledge your daughter, Laura. Everybody who has spoken to Kathy in the last few years will know how relieved it is and lived in a house for me entirely, I think, that she now has a daughter and what you want to keep off two of them. So one of the purposes of inaugural lectures, these basic things are twofold. At least I'm going to make them twofold. One is to talk very briefly about the nature of the lecture. This is obviously a daunting task in this particular regard because we're several lectures, I think. But also to talk about ethics. So these are the Professor Iorns division versus the Kennedy division. And they're not necessarily the same thing at all. How first talk about Kathy, let's talk about Professor Iorns' lecture. So I'm not really very competent to talk about many things at legal school, but I'm particularly not competent to talk about environmental law, other than to say that environmental law that Kathy has risen tonight represents three things that are very important to me about law in general: humanity, courage, and wealth. So you've already seen the obvious importance to Kathy and of the community for which she came. What may not have been obvious to some of you in this room is to bring to which Kathy's scholarship attempts to understand community in general in New Zealand, that she is somebody who believes very much that law comes from particular places and from particular peoples, and much of Kathy's work hasn't been involved in very particular places. And you see one example in the Springs, but also, for example, with the colonial or with the Aotearoa areas, that she knows that law comes from particular people and particular places. And some of you might have wondered, well, how does that relate to statutory interpretation? Because some of you in this room are thinking there is nothing more boring or interest or dull than a statute. And Kathy and I share the revelation, in fact, there is nothing more interesting and exciting than statutes. So the statutes, for me, I think that Kathy are kind of the ultimate representation of community. They are a representation of how human beings attempt to create communities through words. And they do so in a profound way to try and create a new world. And the statutes that we pass and arguments and make about them are our contribution to that world and that creation. Kathy's giving some senses. It's not a dry, boring task law. It is, as I keep on saying, in many bends the way you can talk, is that law is a kind of ultimate humanity. It is something that takes the meanings of words that are constructed in particular contexts and tries to figure out how they might apply to other contexts and how the community wraps around those words and how the community is in many ways created by those words. So law is an active community. Law is also a matter of courage. Kathy's talked about the law reform division. Some of you have probably never heard about the awesome law reform division that used to exist in New Zealand. It is, Sir Jeffrey is nodding. He knows how awesome it was. It was one of the great guardians of New Zealand liberty, even before the New Zealand Bill of Rights Act. In fact, one of the few guardians before the New Zealand Bill of Rights Act. But the Law Reform Division of Justice was run by awesome people, and Kathy, I think, was very lucky to be a member of that awesome team. And they took very seriously the idea of protecting New Zealand. They had courage to protect, but also they had the courage to recognise when things need to be changed. But that's not the courage that I think lawyers really need, because everybody has the courage to think the world should be a better place. Lawyers need the courage to actually try and make the world a better place. And look, that's a difficult process, because that is an imperfect, frustrating, annoying. If you want to have your humility emphasised to you, you should try and do lawless law, because it's very difficult. You can never predict quite what the consequences are, but nevertheless you need the courage to keep on going. And so Kathy's work reflects that into it. The last is hope. We only do law, at least I only do law, because I believe that human beings can be made better, that our world can be a better place to live in. And Kathy's given you that in spades tonight, right? That law is ultimately about hope, that we can do better, that we as a community can figure out better ways of solving our problems than bashing our relatives' heads or just abusing our environment in useless. There is hope. And I just want to acknowledge in the environmental laws here, you need a special kind of hope at the moment. And I acknowledge not just Kathy, but my other environmental law colleagues, some of whom are here, that they have to teach the reality that things are not going that great, but also they need to inspire, hopefully they have inspired some of the students that actually there is sufficient hope that we actually make a difference, and then we'll be able to important role in doing that. So that's the lecture. I don't know whether I really summarised what Kathy said, but one of the great things about oral lectures, you show what people don't really like, and that's a really important value, because all my colleagues are incredibly diverse. Kathy has her own particular way of doing scholarship. Dean did his own scholarship the other day. But that's what's great about my law school. We have such different scholars who take different approaches. Kathy is much more like towards my model of scholarship, completely a little bit, if I can use a little bit chaotic, a little bit of taking the brightest, shiny things, the magpie approach to legal scholarship. Dean's a bit more down the middle. But that's what gives our value, our community value, that we have people who do just thick and things. I just want to say something very briefly about Kathy. As I see when I think this about Dean, that there are many colleagues in this room, all of whom would have different stories about Kathy, different things they could talk about. There might be stories about how impatient Kathy might be when we don't pass certain motions at faculty meetings. There might be stories about her energy or her excessive energy on certain occasions. But one of the things I wanted to really recognise, and I think I haven't seen Lee, I think she's here. Hi Lee, and Petra, and I have seen Kathy that I don't think many other people, maybe his children, have seen. The word I think about Kathy now is not any of those, but it's the word compassionate. Because one of the odd things happening in our faculty is Iorns to it actually left the faculty, who had been our deputy dean for about forever, essentially. And that left us trying to fill the gap. And so I ended up filling part of that gap. No one can fill Iorns' gap completely. But Kathy, for reasons that are only known to Kathy, decided to set interest somewhat rather offshore as becoming dean of students. And no academic wants to be the dean of students. That's actually because it's perceived to be career death. Because essentially you spend your entire time trying to work your way through inane and what seem to be very frustrating university roles in order to help students. And none of those things are shown that unfortunately are that way. I was like, look, our provost, they're well reflected on our promotions frameworks, but are absolutely critical to the way the university works. Because without people like Kathy who step up to do those jobs, a lot of good things will not happen in this university. Because actually goals aren't really important. What are important are people who can passionately ensure them. And I could give you 1,000 examples of Kathy's passion that role. I don't picture you do 1,000 more, I'd like you to do another 1,000 still. That students in these universities, all universities, struggle, things go wrong, things aren't perfect, they make mistakes, they do dumb shit, to be honest, sometimes. And one of our jobs is to see not the person in front of us who's in distress or has done something wrong, but to see the person who will become when they get through that thing. And I would just like to acknowledge Kathy's contribution in that regard, because Kathy did that for students who will now be lawyers in our community, and without Kathy, they would not have finished their studies. And I think in many ways that's the most profound thing that any of us in hands or lives. at the university. So I would say thank you for that. But there's one other person I need to thank who's sitting directly behind her. There's another Reuben in the same way. There's some confusion was caused this afternoon over how many Reubens there actually are. So I just want to acknowledge that shows that this particular career in general over the last 30 years, I think has taken a lot of energy, not just from Kathy, but also a lot of support from her husband. And I just wanted to acknowledge that. I know that's particularly true of the last 18 months. I think that sometimes some of the members of Kathy's family may have suggested that maybe she should keep on doing the job as the students, or that maybe she should limit her time, or that maybe she should not spend 20 hours a day doing it. But I just want to acknowledge thanks not only to my colleagues, but also for the students that Kathy held during the time for your awesome support of her. And we say thank you to you, to Iorns family, and to Kathy. We're supposed to say in these old riches that we're holding someone to promise that they will do more of the same. Now, there's no point here saying I'm going to hold Kathy to account, because we know Kathy already has many promises to keep, and it might actually be our job to help her select some of those promises. And maybe rather than telling her to hurry up, we might need to help her slow down a little bit. But otherwise, thank you, Kathy. Thank you for being our colleague. Thank you from our students, and thank you for tonight.